All right, good morning. Welcome back. I hope you are all doing well. We are at the halfway mark, roughly halfway through the semester. At this point, you should be able to take a look at the midterm from last year. Maybe, if not today, maybe next week, but in this vicinity, you'll now have enough knowledge to actually do the midterm from last year. I encourage you to do so. Go to the library, take 90 minutes, and do it straight through. Don't just look at it. When a student says, oh, I looked at it, you read it over. No, reading it over doesn't actually mean you took the exam. Actually, take an hour and a half and write out an answer. And then show it to me. Print it out and bring it. Don't email to me. I can't do 100 emails. Just print it out, bring it to me. I'll go over to my office, and we can go talk about it after class. OK? Sound like a good plan? And I'd be happy to. I hope all of you come see me, but it's on you. You have to actually sit and do it. Don't just say, oh, I looked it over. That doesn't help you. You have to actually sit there and struggle with it. And you're going to struggle. I'm not going to like pretend. It's going to be like different than tests you've taken before, unless you had me already. It's different. But you're going to struggle a bit. OK. Questions on that? Yes, ma'am.
Is Lindell going to give it to us, or what did you mention?
I think Tim is going to do it during his weekend session. But if you want to do it on your own, you can do that as well. I don't know that he'll give you 90 minutes to actually do it in class. I think he'll go over the answer. So in any event, I'd encourage you to do it by yourself. In other words, I wouldn't go to Langdell for the 90-minute session. Do that on your own time. When Tim's there, I think your time is best used by asking him questions and trying to go over it with him. But again, if you want, talk to me, come to me also. But Tim also got an A in my class. Yes, sir?
Just to make sure, you want to type down, right? Not handwritten.
Please don't handwrite it, please. And for the final exam, please type it. Don't handwrite it. I know there are some people who don't like to type for whatever reason. Get over it. I know that sounds awful. You have to take a bar exam in, about 2 years or so? There's no reason why you should walk into the bar exam with only a pen and paper. You put yourself at a disadvantage. Everyone, if you learn to type, can type faster than they can write. It's just a simple fact of life. And when you type, you can edit easily. You can go back, you can delete, you can move stuff around. When you handwrite and you make a mistake, you have to cross stuff out and draw arrows. And that just makes it harder for the grader to read. You don't want to put the bar examiners at any discomfort. You want to make their job as check, check, check. You don't want to have to make them do any extra work. Just make it simple for them, make it simple for me. So please type final exam, please. If you don't know how to use the ExamSoft, go ask the registrar. They'll show you how to do it. Set it up. Again, the word limits are the same. Each question is 1,000 words. Please do not go beyond that. If you go beyond 1,000 words, I stop reading. I stop reading at word 1,000. It's very easy for me to do that. This keeps you all on the same level. It does not give an unfair advantage to the person who can type 5 million words in an hour. I know who you are. I was that student. You can't do that in my class. It doesn't work. It's an equal playing field for everyone. All right, questions on that? All right, well, please. Oh, wow, almost everyone's here. Only 2 people are out. That's very good. Please sign into the attendance when you can, as soon as you can, that is. We're starting a new topic. Again, this is class 13, so we're roughly, is it 12 or 13? I can't remember. 12, I'm sorry. So we're class 12. We're roughly halfway through the semester. And we're moving on to a different area. The first half of the class concerned what you might call the structure of the Constitution. We talked about the separation of powers. We talked about Congress's powers. We talked about the president's powers. We talked about federalism, that is the balance of powers between the state and the federal government. All of that stuff was based on the original Constitution, the Constitution that was drafted in 1787. There were some changes. We have the 11th Amendment, but this was basically the 1787 version of the Constitution. Very often when you hear people criticize the Constitution, say, well, the Constitution was drafted in 1787 and had these awful things. It condoned slavery and it had the 3/5 clause. That all true, but we had stuff that happened after the fact, and that's what the second half of our class is about. The second half of our class is the post-Civil War Constitution. And the post-Civil War Constitution was an entirely new frame of government. People who lived during that time said that our government became unrecognizable after the 1860s. It was completely different, for better and in some regards for worse. We'll see later in cases next week. But the reason why this is important is I want you to think of the founding in two eras, right? We had a founding in the 1780s, and then we had a second founding in the 1860s, right? We always think of James Madison, right, and Alexander Hamilton as the founders, but there were other founders. John Bingham, never heard of, right? Jacob Howard, you've never heard of him, right? These were people who were involved in the ratification of 13th, 14th, and 15th Amendments. In many regards, Abraham Lincoln was a founding president for the second founder. He was one of the great abolitionists of his era in the White House. So you have to sort of chop this class up in half, right? The first half and the second half. They all go in the same syllabus, for sure, but they're like two separate classes. And in fact, at most law schools, not us, there are two ConLaw classes. You have ConLaw 1, which is the structural stuff, and ConLaw 2, which is the rights stuff, 14th Amendment. Unfortunately, I have to cram it all into for one class. I wish I had 6 hours, but I have but 4. Not my choice. I dissent on these matters, but I do what I'm told. So our topic today focuses on the second half of the class. Any questions so far? All right, let's start a question, and this is one where I'm telling you there's not a right or wrong answer. So this is truly a poll, rather than a right or wrong answer. I want to see what you guys think on this one. So the question is this: the Constitution of 1787, that is the Constitution before ratification of the Reconstruction Amendments, excluded slaves from citizenship. True or false? Oh wow, moving pretty quick with answers here. Okay. Maybe another 5 seconds. Get your answer in. All right, let's see what the numbers show. That's pretty close. Now, I checked both of them because I think they're both probably right, depending who you ask. Right? So the question is, did the Constitution exclude slaves from citizenship? At the time, in the early 1800s, people did not agree with this question. And it wasn't the divide you would think, right? It wasn't just, those who favored slavery said they're excluded, and those who were abolitionists said that they're included. Even among abolitionists, that is, people opposed slavery, there was a divide, right? There were some abolitionists, Frederick Douglass, most famously, Lysander Spooner, who argued that the Constitution did not approve of slavery. And there were some abolitionists, his name was, one was called Garrison, who argued that the Constitution was an evil document. And the Constitution did approve of slavery. Right? Who was right? I can't give you a right answer. Right? I happen to think Lysander Spooner and Frederick Douglass are correct, but that's just my opinion. I don't pretend that's gospel. That's the God-given truth. But what we do know is that the Supreme Court agreed with Garrison. What we do know is that Chief Justice Roger Taney agreed that the Constitution sanctioned slavery from the outset. Yes, sir.
I'm kind of jumping ahead. But
Sure. Well, I might pull you back, but go for it.
The Dred Scott case.
Yeah.
Had it been Chief Justice Chase rather than Chief Justice Taney, do you think we would have had a completely different outcome?
Well, it's a good question because Chief Justice Chase died. I'm sorry, Chief Justice Chase was appointed by President Lincoln some years later. So it's a bit of a difficult counterfactual. The Civil War had, Chase was appointed after the Civil War. So I'm not sure if I can even answer that hypothetical. But the vote in Dred Scott was not 5-4, it was 7-2. So I don't even know if one vote would have made that much of a difference. But let me come back to the point I was making a moment ago. We have a debate today about whether the Constitution was born in original sin, about whether the Constitution was born as a pro-slavery document. And one of the irony is the wrong word. I don't want to say irony. But those who say that the Constitution was born in original sin, it was a pro-slavery document, are endorsing Roger Taney. Right? To say that the Constitution was a document that proved slavery is to say that Roger Taney was correcting Dred Scott. It's one of these perversities which I don't fully grasp, but it's a common discussion. And to say that Roger Taney is right means Frederick Douglass and others were wrong. And I happen to think Frederick Douglass had a better reading of the Constitution. Let's walk through this a bit, okay? Before we can even get to Dred Scott, I want to start by talking about just things like that. Okay. End class. There we go. Okay. Before we get to Dred Scott, I want to talk about a provision of the Constitution we've referenced before, but was very important. And that is the Privileges or Immunities Clause of Article 4. And we talked about this in a few cases. It provides the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. It's written in a weird way, right? What does this actually mean? What this provision is getting at is that there are certain rights, what are called privileges and immunities. Okay, whatever they are, that's what the rights are called. And let's say the state of Connecticut guarantees its own citizens certain privileges. Okay, I am a New Yorker. I come in to New York and I travel to Connecticut. Right? I'm a citizen of New York, I go to Connecticut. What this provision means is that Connecticut must give me the same rights that it gives to its own citizens. Understand? Okay. What are these privileges or immunities? Basic stuff. The right to protection by the government, the right to acquire and possess property, these sorts of basic things, right? We might call inherent rights. Now, this provision had a very important role in the slavery debate. Why? We had some free states and some slave states, roughly divided in the middle. Let's say that you were an African American living in Boston, right? You were a free person, you owned property, you had everything you needed, right? You were a sailor, and then you traveled on a boat from Massachusetts down to South Carolina. You were just doing your job, traveling on a boat. Once you got into port in South Carolina, you were then arrested, and they accuse you of being a runaway slave, whatever other bogus charges they make up. You say, wait a minute. I am a citizen of my state, Massachusetts. You must give me the same rights that you would give a citizen of your own state, South Carolina. South Carolina says, no, 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 no. You cannot be a citizen because of your race. even if your own state considers you a free person, a free citizen for your state law, you cannot be a citizen in our state. You can see how closely the issue of slavery was bound up with the issue of citizenship, right? If you were a citizen, you could not be a slave. But if you were a slave, you could not be a citizen. You're either one or the other. Because once you're a citizen, you get these rights. You'd also get the right of free speech, the right to bear arms, the right to do other things that citizens ought to do. So even before Dred Scott came around, there was this debate about who was and was not a citizen. Okay. Does the Constitution define citizenship? The Constitution of 1787 does not define citizenship. It says, just doesn't say who it is. It says Congress is a power of naturalization, which means if you're coming from another country, how to become a citizen. But what about those who are born in the United States who are not naturalized? How do you become a citizen if you're born here, not immigrating from another nation? In the early years of the Republic, it was largely a factor of state law, that the states got to decide who was and was not a citizen. So then go back to our first question, right? Did the Constitution approve of slavery? Did it guarantee a right to slavery? Well, you have the abolitionists like Frederick Douglass and Lysander Spooner, who looked at the Constitution and said, no, no, no. It doesn't use the word slavery. It uses phrases like other persons, right? Or persons held to service, right? And that the framers went out of their way not to reference it. And by doing this choice, they were deliberately not approving of slavery. But then you have the other group, like the Garrisonians, who said, no, no, no. You have clauses about the the importation of persons, right? Which is obviously a reference to slavery. You have a provision about people being held to service or labor escaping. This is obviously a reference to runaway slaves, right? And so this early debate in the country over who is right? Was the Constitution pro-slavery? Was it silent on slavery? And you had the debate about the sailors in South Carolina, for example. How would they be treated? Then you had one other debate, which I want to reference, which involves the Fifth Amendment of the Constitution. And this one cuts in two ways, right? It provides that no person shall be deprived of life, liberty, or property without the due process of law. Okay, notice this is not about citizens, right? Put aside the debate for a moment of whether a slave is a citizen. He is a person. I think most people would agree with that. I think everyone would agree with that, at least at now, maybe not at the time, but a slave is a person. How can a person be enslaved without any sort of proceeding, right? By virtue of the fact of being born, the person is enslaved from birth, right? Douglass and others argued that the slave was being deprived of his liberty, his freedom, without any sort of process, without any sort of legal protections. Well, that's what one side argued. What did the other side argue? Long before Roger Taney came around the scene, members of Congress argued that owning a slave was protected by the Constitution. They argued that the slaves were in fact property. They owned them. And for the government to deprive them of this property would violate their rights. Indeed, it would require compensation. We talked about Abraham Lincoln with the Emancipation Proclamation. There was a legitimate debate at the time over whether the emancipation was a taking of property. But there's a tension here, right? If in fact the slave owners were right that they were being deprived of their own property, then the slaves were not people, and they were not guaranteed the due process of law. But if Frederick Douglass and the others were correct, the abolitionists were correct, that these slaves were people, then they could not be property, and they could be freed. So you can see at the very early days, you had these debates about the text of the Constitution and about how these provisions would be interpreted. Now, these debates played out in the political realm. They didn't get to the courts until some years later. You had Prigg, which was a fugitive slave case we did the second week of class. But these are primarily political debates. Okay? And one of these political debates involved what was called the Missouri Compromise. I realize I'm lecturing a bit, but this will be easier than trying to drag it out of you. The Missouri Compromise. Okay, what was the Missouri Compromise? Think of the map of the United States, right? The northern states were primarily free. The border states were kind of in the middle. And the southern states were pro-slavery. As we had westward expansion, we moved towards the coast of the Pacific, everyone recognized we're going to have an issue. If you admitted more free states, then the slave states would be underpopulated. And Congress could then abolish slavery. But if you admitted more slave states, the slave states would have more political power, more votes in Congress, and they could maintain slavery. So a compromise was reached. And it wasn't a very good compromise. It didn't really work. But it was called a compromise. And it was called the Missouri Compromise. Along where the state of Missouri is, I'll show you a picture in a minute. Along where the state of Missouri is, Congress basically drew a line. Okay? And what this line said is that if you have any new state above the line, it was going to be a free territory. Here, I'll show you the map, right? So see this like white line over here? Any new territory above that line would be free. Any new territory or state below that line would be slave. You notice it goes right about the Texas Panhandle, so it's right around where Texas was at the time. Why was this significant? It was designed to keep the balance stable, right? To keep the balance about the same. The southern states actually got really creative. They tried to basically turn the Caribbean islands into states, and they wanted to turn parts of Latin America into states because it was below the line, right? They got creative, trying to think of different things. But this was designed to sort of keep the equipoise together. But this wasn't a very good compromise. Why? Well, what happened to slaves who traveled to northern states? The northern states long had policies that if a slave touched free soil, they say, or had a breath of fresh air, it's a beautiful image, right? You breathe fresh air, you're free. They become emancipated. Now, how could that be? Right? Didn't we have Prigg, which said that if runaway slaves goes to Pennsylvania, they get brought back down to the south to Maryland. And that's the political context in which Dred Scott arose. Dred Scott was just one person, a famous person now, but his case was all too common, where slave owners would travel from south to north, bring the slaves with them, often entire families, and then the slaves would try and go to the courts and seek emancipation, seek to be liberated. And then the courts would be called upon to resolve it. Okay? All right, so any questions on the to the basics? That's like a 10-minute overview of like 100 years of American history. I tried to squeeze in, there's a lot there. Any questions on that? I'll try to do as best as I can. If you haven't, there's a video in the library on the history of the 14th Amendment. It's our longest video of the series. It's like 25 minutes long. It's basically like a sitcom. I mean, it's not funny, but it's basically the length of a TV show. Watch it. I usually don't say watch the videos, but watch them. It's very well done. And it walks you through the entire history, and I think it'll be very helpful for you. Okay, you can watch it on double speed if you want, but it's there. All right. Any questions so far? All right, thank you. Where am I? Who's next? Who's been patiently waiting? Yes, sir. You want to give me the facts, please, in Dred Scott?
So Dred Scott, his owner migrated to a military base.
Very good. And okay, so just be precise. Where they start off? What states do they start off in? The states are important. You usually don't care, but here the locations are important.
I believe it was Missouri,
Yes, sir.
and then they migrated to
Minnesota, close enough. Yeah, yeah. All those box states all look alike. Yeah. Sorry. Yeah. Go ahead. If you're from Wyoming, I'm sorry. Yeah. Yeah.
When the owner died, his wife took over the litigation,
Yeah.
and she then succeeded that responsibility to her brother.
That's right.
And that's what Dred Scott made a complaint utilizing a provision that indicated that if he was on a free soil,
Yeah.
he was entitled to free rights.
Very good. Yeah. Very good. Okay. You want to keep going if you want?
So,
Keep going if you want.
he was entitled to free rights. And then the trial court approved Dred Scott's
Good.
motion,
That's right.
but the Supreme Court reversed it.
Very good. Very good.
And
Okay.
later on, Irene, her second husband, bought their freedom.
Oh, perfect. Very good. He gave you twice as much as they wanted, but very good. No, it's good. It's good. Very good. Thank you. All right. Let's just walk through the facts one at a time because the facts here are actually very important, right? This is actually, let me just show you a photo. This is Dred Scott. It's an iconic photo. How many of you have seen this photo before? Probably a lot of you. This is a case that we describe as being in the anti-canon. I just want to tell you a little bit what that means. Randy likes that phrase a lot. He uses it all the time. I'll use it a little bit less. This is the sort of case that I think just about everyone, I'd say everyone, but everyone thinks was wrong. But it's not enough to understand why it's wrong. You have to understand how the court got there and why it did what it did. And that's the important element of saying it's anti-canon, right? It's this really bad decision, but we're studying it as a lesson in how not to do constitutional law, right? If you are emulating Roger Taney in your decision, you are probably going to lose your case, right? This sort of mode of thinking is not how you're going to win your case for whatever you want to do. Okay, so the case involves Dred Scott and also his wife, Harriet. They were married not in Missouri, but they were married in a free territory, which was, it's basically Fort Snelling. That's Dred, and that's Harriet. Okay? They were married in Fort Snelling. Okay, where is Fort Snelling? It's present-day Minneapolis, Minnesota. Okay? If you ever go to Minneapolis Airport, Fort Snelling is a base you can still visit, and it's about 5 minutes from the airport. I need to get there one day. I've never had enough time, but it's right in Minnesota. The important point is that Fort Snelling was in free territory, right, by virtue of the Missouri Compromise. So Scott was brought there with his family. They were there for some time. At some point, they traveled back down south. And this is, I can't even imagine, his wife gave birth on a steamboat. Can you imagine that? Just any of you have any wives or sisters? You all had mothers, I guess, right? Just giving birth on a boat. Like I can't even fathom that. But the daughter, Lizzie, was actually born on this boat. I still can't even imagine that. North of the Missouri line, which meant she was still in free waters. Everyone with me? Okay. Initially, Dred Scott sued for his freedom in the Missouri courts. If you ever go to St. Louis, you know, the St. Louis Arch, you've all seen it, right? About a block from the St. Louis Arch is the courthouse. It's still in existence where Dred Scott was tried. The actual room was destroyed at some point, but they recreated it. It looks more or less the same. Initially, the trial court ruled in favor of Dred Scott because the policy had been if you were a slave and then you go to a free territory, you were then emancipated. You were freed. You breathe the free soil. You breathe I actually don't breathe soil, but you breathe the free air, so to speak. It was appealed to the Missouri Supreme Court, which at the time only had 3 members. I'm not quite sure why, but there were 3 judges, a pretty small court. And the Missouri Supreme Court reversed itself. They said, no, that's not our law anymore. Our law is that you are not emancipated. Dred Scott did not appeal that decision to the U.S. Supreme Court. He could have, but he didn't. Instead, he did something else. He said, let me try my luck in federal court. Right? Let me try my luck in federal court. Now, you all remember from civil procedure, at least you should remember, diversity citizenship, right? How does diversity citizenship work? Just remind us.
Two people from different states. Then you get to a federal court.
Very good. Well, you said 2 people. Just
Oh, well.
yeah, no, just you know what you did, right? Yeah. So say it again. It's not just 2 people. What does the diversity statute say? It's not 2 people from different states. Not people.
2 citizens.
2 citizens, right? And you probably never thought about that in civil procedure, right? Who cares, right? Everyone's a citizen. Well, that was the issue in this case, right? So what were the parties in this state? Where were they from in this case?
Dred Scott was he from Missouri?
Oh, he was from Missouri.
Yeah, okay, and then
Where was Sandford from?
New York.
Okay, so Sandford was a citizen, no doubt. Was Dred Scott a citizen?
No.
Yeah. Right? So the reason why, we don't know exactly why, but probably the reason why this case went to federal court was that Dred Scott and his attorneys were trying to get a decision stating that he was a citizen for purposes of federal law. Because if he was a citizen for the diversity clause, then he's also a citizen for the privileges and immunities clause. Everyone understand what I just said, right? If he was a citizen for purposes of diversity jurisdiction, then he would also be a citizen for purposes of Article 4, the privileges and immunities clause. Right? Think of the black sailors who were being captured in South Carolina. Right? This would be a decision that would prove that the sailors were correct, that Frederick Douglass was correct, that Lysander Spooner was correct. But if the court ruled against Dred Scott, that would be endorsing the Garrisonian perspective, that these were not citizens, that they were not even people, which is where eventually the court went with this, right? Everyone with me right now, right? Everyone understand why they went to federal court instead of staying in state court. They wanted that ruling about whether he was a citizen. Well, let me tell you, it didn't work. It did not work, and it backfired in a way that few people, I think, could have anticipated. All right? So Dred Scott went to the Supreme Court, and the vote was 7-2. Okay? Now, when I have you guys read Dred Scott, it's a long opinion. There's a lot going on there. I want you to understand that Tawney was wrong on just about everything he wrote, right? I mean, I'm sure there was some stuff that was right, but like almost everything he wrote was incorrect. All right, and let's start with the most basic rule, right? Angela, let me ask you a question. If, let's just say I go to federal court, right? I'm a citizen of Texas, you're a citizen of Texas, right? I sue you in federal court for diversity jurisdiction. I say, you committed a tort and we have diversity. What should a court do if I sue you in federal court in Texas for diversity? What's the easiest thing that should be done? What would usually happen? I'm from Texas, and you're from Texas. What would the court do with that case?
Send it back.
Send it back where?
Take it.
Exactly. They dismiss it, right? So if a court were to write an opinion, how long would that opinion be?
How long?
Yeah, maybe a sentence or two?
Just say no jurisdiction.
Bingo. Exactly, right? If I were to sue Angela in federal court, and I'm a citizen of Texas, and she's a citizen of Texas, and I go to federal court and say, Josh, what the hell are you doing, right? Case dismissed for lack of jurisdiction. Angela, is that what we got here by Mr. Tawney? Did he write a one-sentence decision for you guys to read? No. Okay, thank you. He did the exact opposite of what a judge should do. And let me explain why. Usually judges try to avoid difficult questions they don't have to. Right? If a court lacks jurisdiction, the answer is a one-sentence dismiss for lack of jurisdiction. Right? Maybe a paragraph, right? I'll give you a page. Give me a page, right? Because courts say, why am I deciding this very important constitutional question if the parties don't have jurisdiction? Tawney did the opposite. He wrote, in your book it's what, 20-something pages? It was a few hundred pages, the actual, it's some of the longest opinions ever. In fact, his opinion was so long, the reporter of decisions said, I'm cutting some stuff out, it's too long for me, right? Everyone was writing by hand back then. He wrote this opinion that was like, I can't remember, it's in the hundreds of pages. It's a long decision, one of the longest ever rendered. Now, Designated, let me ask you this question. Why do you think Tawney went out of his way to write hundreds of pages? I mean, this was a long opinion on all these questions that were not even before the court. Why do you think he went out of his way to do this entire long thing?
Someone settled the question of
Yeah.
whether slaves could be citizens.
Yeah, you're right. But why do you think he wanted to settle this question? That's the why.
Because it's been like an ongoing question
Yeah.
in like the South and free states, like whether it's
Yeah.
gonna be citizens.
Let me ask you just one more follow-up. What do you think would have happened if they dismissed this case? And they said, sorry, Dred Scott, no jurisdiction, you lose. What do you think might have happened in the next one? What would have happened next?
They probably would have had another case.
Bingo. Bingo, exactly right. Thank you. Tawney wasn't an idiot. I mean, all things considered, he was a smart guy. I don't want to say he's an idiot. He did something insane, right? He screwed up in a big way, but he wasn't an idiot. He was aware that this issue was not going to disappear. There'd be another case that might come along from state court where there was jurisdiction. And then they'd have to do this entire decision all over again. Everyone understand? Had Dred Scott appealed this from state court, it'd be a completely different decision because the citizenship question is not present. In that case, you have to decide straight up, are these people or are these property? So instead, Tawney wanted this case. We could say, no, they're not citizens, they're not people, and go down the list, all the other things he said. Right? Tawney wanted to resolve this dispute. He wanted to give a clear answer to a legal question that had been dividing the country for almost a century. Right? That was his goal. Now let me tell you something. Didn't work. Did not even close to working. Right? Why? Well, courts are not good at resolving political disputes. They're terrible at them, right? When you have an issue that's very divisive, to have unelected judges try to render a decision doesn't work very well. And pick your issue, right? Abortion, guns, whatever issue you want to pick. When you actually have judges making these decisions on Bush v. Gore, whatever, pick your case. People are like, who the hell are they to tell us what to do? Who's that guy in the robe telling me what the answer is, right? Who's that guy in the robe telling me I'm not a person, right? Who's that guy in the robe telling me I'm not a citizen, right? Courts don't do well to resolve political disputes. But of course they do, right? I think Angela said a minute ago, we could have had a one-page decision, one-sentence decision, no jurisdiction. What's another case we had this semester where the court lacked jurisdiction, wrote a hell of a lot? They wrote this long opinion. Yeah. Marbury. Yeah, first day of class. Remember Chief Justice Marshall said, well, we don't have jurisdiction to order Madison to give over the commission, but let me write 30 pages on judicial review. Right? You all read it. It was a long decision. It was in your notes. So I mean, again, what Tawney was doing, in hindsight was insane, but he was maybe taking a page from John Marshall, right? Saying, well, there's no jurisdiction, let me declare that slavery is constitutional, right? The difference, of course, is that in Marbury, John Marshall had the good sense to not order anyone to do anything. It says, all right, there's no jurisdiction, guys, just stay where you are. Whereas in Dred Scott, his decision had an impact to declare that an entire race was non-citizen. An entire race, whether free or slave, was not even human beings, not people, not desired, not entitled to due process of law. Everyone with me? Yes, sir, Ruben.
In Craig, they utilized the fugitive slave clause, which says
Yeah.
no person.
Yeah.
So did he just like ignore that? Or?
Well, I think I said a minute ago, almost everything in his decisions are wrong, right? So that's a good point. The Constitution, at a minimum, says that they're persons, people. Tawney disregards that. He also disregards the fact that at the time of the framing, several states permitted slaves to own property, to vote, etc. Right? He disregards a lot of history. I think the dissents point this out. So I don't want you to take things that Tawney says as correct, and I think he points out a good error in his opinion. Right? But I want to take one more step back before I actually get into I haven't even talked about the case yet. We haven't gotten to the mechanics. One other point. This decision was called Dred Scott against Sandford, right? Who were the parties? It was Mr. Dred Scott and Mr. Sandford. Okay. The only dispute that Tawney was there to resolve was the conflict between Dred Scott and Sandford. Caroline, did he limit himself to that sort of conflict? Did Tawney only decide the dispute between Dred Scott and Sandford about whether he was a slave or a person?
Oh, according to Tawney, no.
What else did Tawney decide? What really big issue did Tawney go ahead and resolve?
Whether slaves in general.
Well, there was a big thing he declared unconstitutional.
Oh, the Missouri Compromise?
Yes. Now, Caroline, let me ask you a follow-up question, please. Who enacted the Missouri Compromise? Where'd that come from? Congress, very good, yeah. Was Congress involved in this case at all?
No.
Was Congress a party? Was the federal government a party to this case? Was, the federal government asked to file a brief in this case? Okay, Caroline. Was the federal government bound by this decision?
According to Tawney, yes.
Ooh, boy. I see you're shaking your head no? Tell me why. I think you're correct, but just tell me. Oh, no, it doesn't. No, yeah. You're shaking your head. I see you shaking your head. No, I think you're right. Tell me why.
Exactly why.
Well, yeah. It sounds wrong, right? Let me just bring it back to CIFPRO, right? Remember the concepts of estoppel and res judicata, right? If I sue, Josh versus Josh is bad. If I sue, I'll confuse you way too much. If I sue Ruben over here, right? And it's Josh versus Ruben. See, Josh versus Josh confuses. Josh versus Ruben, right? And I get a judgment against you. Is Martin bound by that judgment? No, right? If Ruben does the same thing that Martin does, I can sue Ruben, but I can't sue Martin because there's no judgment. It's the same issue here, right? Let me explain why. In order for Tawney to actually declare the Missouri Compromise unconstitutional, Congress has to be in the case somewhere, right? The federal government must be involved. That way, Tawney can say, the federal government, you cannot enforce Missouri Compromise anymore. You can't enforce it, right? You must allow slavery up in Minnesota. But that wasn't what happened. He declared that the Missouri Compromise, was valid in a case between these two guys. So this gave rise to Abraham Lincoln. Lincoln was a lawyer. He was a smart guy, right? Very smart guy. And he said, well, you know what? Mr. Tawney, you wrote your opinion. That's very nice. It's a valid opinion between Dred Scott and Sandford. Poor Mr. Scott was not emancipated. Eventually he was, but at least not in this case. But Congress does not need to comply with your decision, Mr. Tawney. We don't need to comply with it. Why? Because we weren't party to the case, right? There's no judgment against us. And let me tell you something. After Dred Scott, do you think that Congress suddenly said, okay, let's get rid of the Missouri Compromise? Nope. Do you think they suddenly said, okay, let's get slaves into Minnesota? Nope. Do they suddenly say, okay, let's kick all of the African Americans out of the military? Nope. Do they suddenly stop issuing passports to free blacks? Nope. Right? all the things that Tawney would have wanted to happen did not happen. So did Congress ignore Dred Scott? I don't like the word ignore. I think that's the wrong word. I think the better word is they said, well, that's a nice decision. We're not party to it, so we're not subject to it. One second. And as a result, they continue giving passports to free blacks. They let free blacks into the military, right? They didn't enforce slave laws inside the jurisdictions in the North. They basically treated Dred Scott as like a nullity, right? As just like this decision that doesn't have any legal effect, right? And that's what happens. We have a decision that people find so morally repulsive that it just doesn't take weight. Yes, sir.
My question was, would it be fair to say they just rendered Justice Tawney's opinion as just that, an opinion?
A decision between those two, that's how I would phrase it, right? Between Dred Scott and Sandford, that's it. And that's how Lincoln argued it, right? And there's actually a lot of good stuff in this because Lincoln's Attorney General considered whether he could grant citizenship to some free blacks who joined the military. And he basically said, in his opinions, we are not controlled by Dred Scott. He issued a decision in conflict with Dred Scott, right? Everyone with me? Now you may say, yes, go Lincoln, go, right? That's how you do it, right? Now let me pour some cold water on that just for a minute. A little bit of cold water. I know I always have to make you guys sad at 9 in the morning, right? A little bit of cold water. This sort of thinking where you limit the case to the parties doesn't always work out in ways that you might like. Let me explain why. During the Civil Rights Movement in the 1960s, the segregationists adopted this playbook. Right, the segregationists adopted Lincoln's playbook. Huh? Let me explain why. We have a famous decision, Brown versus Board of Education. Very famous case. And that case involved the school districts of Kansas and South Carolina, Virginia, and one other state I'm blanking on. Okay, so four states. Okay? Was Arkansas a party to that judgment? No, it wasn't. So the Little Rock School Board said, okay, we're not bound by Brown. It didn't affect us, so we can keep segregating our schools. Oh, right? In the aftermath of Brown, school districts across the country said, Supreme Court didn't talk to us. We can ignore it. It's not our problem. And they said, you have to go sue us again. Give us another judgment. And they got really, creative's a bad word. They got creative, right? They said, oh, you know what? You sued the governor? Okay. We'll send out the local police department. Oh, you sued the local police department? We'll send out the state guard. Like whoever was being sued, they would just send some other division to block kids from going to school. So this sort of let's limit Supreme Court judgments to the facts was adopted by the segregationists in the 60s. And we'll talk about that in about maybe 2-3 weeks. But it's not all, it doesn't always go to the way you might want it. Okay. All right, everyone with me so far? We're still an hour and haven't even talked about the case yet. Okay, let's actually talk about the case. Brandon, let me ask you a question. How does Tawney, and by the way, it's not Taney, it's Tawney, whatever, that's how they pronounce it. How does Tawney come to his first conclusion that Dred Scott is not a citizen? How does he come to that first conclusion? He gives a lot of stuff, but just walk me through the general argument.
Since historically they were never citizens.
Okay, what sort of evidence is he looking at?
How slaves were treated in the past.
Okay, very good. So Tawney's first argument about citizenship is historical in nature. He argues that since the time of the framing, slaves existed, and that people of African descent were not treated in the same fashion as were white people. The difficulty with this position is that he's not correct. At the time of the framing and before, there were several states that actually gave free blacks the right to vote, the right to own property, and other privileges. So he's wrong as a historical matter, right? But I think his argument is bolstered by the fact that you have references to slavery in the Constitution. right? You have the Fugitive Slave Clause. You have the Fugitive Slave Trade Clause, right? And at a minimum, there's a debate, right? Does the Constitution sanction slavery? And here, Roger Taney says it does, which is why people today who argue that we have a pro-slavery Constitution are agreeing with Roger Taney, which is just it's a perversity. I think Taney was wrong. If Taney was wrong, then Frederick Douglass is right. But Taney adopted this sort of pro-slavery perception. Okay? Okay, everyone with me? All right. So then, Ray, because Scott wasn't a citizen, what happens to his case? It was dismissed. That's correct, right? But he didn't stop there, did he? What else did Taney do? No. After Taney found the court lacked jurisdiction, what did Taney do next? Did he just stop writing?
No, I don't recall.
Hmm? Yeah.
He kept writing and he said if we did have jurisdiction.
Yes. Yeah, and that was a question I gave you to before, right? This is kind of weird. It said, well, assuming we have jurisdiction, can a court assume there's jurisdiction?
No.
No. Jurisdiction is basic, bedrock. You can't assume jurisdiction. You either have it or you don't. So then Taney moves on to talk about the Missouri Compromise, right? Which again included the Wisconsin, not Wyoming, the Wisconsin Territory, which is present-day Minnesota. Okay? And he actually concluded that the Missouri Compromise violated the Due Process Clause because it deprived the slave owners of their property without due process of law. Now, I want to talk about this for a minute, right? Sergio, let me ask you a question, please. When I say you can't take away someone's property without due process of law, what does that actually mean? What does that actually mean?
Without a day in court.
Yeah. When I say due process, you think of, well, process, right? You get a hearing, you get a trial, you get some sort of day in court, right? Is that what Taney's arguing here, that you should get some sort of hearing before they take away your property? Is that what Taney's argument is?
I mean, I think it's part of it, but I don't think it encompasses.
Yeah. So I want to introduce you to two concepts, right? These labels did not exist in the 1800s, but they exist today. The first one is called procedural due process. And the second concept is called substantive. Procedural process, due process, sorry. Too many processes, right? The first one is called procedural due process. And the second one is called substantive due process, right? Again, these labels did not come into existence until the 20th century, but they're helpful for you to think about. All right. What is procedural due process? If the government wants to take away my property, I have to get certain procedures. I have to get a trial. Maybe there's a judge. Maybe there's a jury, right? I have notice about this hearing. I have an opportunity to be heard. I have the right to examine witnesses, right? I have the right to give testimony, right? These are all the sorts of processes which our courts give people. That's not what Taney's arguing. Taney isn't saying that, well, the government can take away your slave if they give you a hearing first. Taney's making a different argument. What he's arguing is that this due process clause actually protects rights. And no matter what process you're given, it's not enough. Right? That no matter what process you're given, it's not enough to save you. Right? Just imagine where you walk into court and you're on trial for murder. And how does a judge decide if you're guilty or innocent? He flips a coin. It's a fair coin. It's weighted equally. Here's your process, right? Take a coin, heads you win, tails you die. Are you given the process that you're due? Well, it's a process. But the argument is that there's some rights that are so important that no amount of process can justify your deprivation. And that's what Tawney's getting at. He's saying that the right of the slave owner is so significant, so important, that no hearing can deprive him of that, right? No trial. In other words, the government cannot enact a law to deprive a person of this property or this liberty. Just no law can be enacted, right? This is not what we might call it's not what we call procedural due process. This is the label that came to be known as substantive due process. The idea that the word liberty in the Fifth Amendment has a substance or has a meaning, right? That no amount of process can allow the government to deprive you of that liberty. This is a controversial issue, right? Why? A lot of the 14th Amendment cases we'll study this semester are based on the concept of substantive due process. For example, a right to abortion, right? The Constitution says nothing about abortion. It says nothing about it. But the courts have held that one of the liberties that women have is the right to terminate a pregnancy. And it's not that, well, you can get an abortion if you give someone a trial. No, that the right exists independent of whatever process you're given. Or consider a right to sodomy, or a right to contraception, or pick your right. Right? These are not written in the Constitution. They are considered liberty, which the government cannot deprive you of. Now, one of the criticisms of substantive due process is that, well, Roger Taney invented it. In other words, one way that abortion decisions are often attacked is say, well, you're doing the same thing Roger Taney did, right? Roger Taney said you have a right to own slaves, and you're saying you have a right to terminate a pregnancy. The Constitution's silent on both. Taney didn't invent this. This argument predated him. Members of Congress in the early 1800s made this exact same argument. So Taney wasn't original here. But you'll often see criticisms of substantive due process invoke Roger Taney. You will also see critics of originalism invoke Taney, saying, look, see, Taney was an originalist. He said at the time of the framing, the slaves weren't citizens. But I think Taney was probably wrong on that front as a historical matter. But we will spend probably 3 weeks on substantive due process. And just keep in mind the Dred Scott decision. It's not, it's not essential, but it's often linked together. Okay. Everyone with me? Okay. All right. So because Taney found that the Fifth Amendment was violated, he ruled that the Due Process Clause renders the Missouri Compromise unconstitutional. Therefore, Dred Scott could have never become free. Why? Because it was not a free territory. Even though the federal government considered Wisconsin as a free territory, Taney says it's not. And in the natural state of things, it remains a place where people can own slaves. Therefore, Scott was never emancipated. Now, Richie, let me ask you a question. What was the effect of saying that the Missouri Compromise, I'm sorry, let's say this again. What was the effect of saying that the free states or the Wisconsin territory was not free? What does that mean for people other than Dred Scott? I asked that question poorly. Let me try another time. What was Scott's argument about why he was free? What argument did Scott rely on?
Scott relied on...
What law was he citing? Where did his case start out?
in state court.
Right, and what law was he relying on to make his argument? What was his argument of why he was emancipated? Richie, what was Scott's argument? Why did Scott think he was emancipated? By virtue of what? What happened?
By virtue of him crossing into free.
Right. And what did Missouri law say at the time about how one becomes a free person? What has to happen? What was that famous expression of how a person becomes free?
The soil.
Yeah, bingo, right. That by virtue of stepping foot on free soil, you become free. One more, Richie, then you're done. What did Tawney say? Was Wisconsin free soil?
I'm assuming no.
Okay, good.
Free soil.
So let me just stop right here, right? Thank you. Tawney said Wisconsin was not free territory. Therefore, state law was irrelevant, right? It didn't matter whether state law said free soil, free person. What Tawney said is it ain't free. Because it's not free, it doesn't matter what the states decide. You see, this is the point Designate made a few minutes ago. He was resolving not just Dred Scott's case, but all other cases that may come down the pike. That merely by traveling to a free territory, you cannot be emancipated because it wasn't free in the first place. That's why he had to reach this question, right? And let me go back to Ruben's question. I sort of skipped it before I want to address it. Tawney uses some very, very awful language, and I don't know any other way of putting it. The unfortunate race, right? He puts these words in there. Ruben, let me ask you this question. Why do you think Tawney went so far to dehumanize these people? What do you think he was trying to do with his opinion? He was deliberate. He wasn't choosing this language, by accident. He could have just sort of, did a soft version, but he went really hard.
Maybe he was a sympathizer to the South.
Well, that might be true, but what do you think he was trying to do with his opinion about the Due Process Clause, the Fifth Amendment? It says you can't be a person, right? If you're a person, you have liberty. What was he trying to say there?
That they aren't afforded the right to due process.
Because they're not
People.
Bingo, right? The reason why Tawney has to go out of his way to describe these people as basically property was to take them out of the scope of the Due Process Clause, right? Maybe they're persons held subject to labor, right, or subject to service, but they're not persons who are entitled to liberty, right? He has to dig himself into this really deep hole of describing these people as non-persons to avoid any possible instance in which they might be given liberty under the Due Process Clause, right? Which is why I told you at the beginning of class, almost everything he said is like just wrong and bad, right? Just from top to bottom. But he felt compelled to do this, right? His opinion was not originally the majority. Originally he had a concurrence, but things sort of moved around. He became the majority, right? The concurrences, they're bad, but they're not like, they don't use a sort of awful language. Is that a hand? Okay. All right, I think I'm almost done with Tawney. Questions in the majority opinion. I think I got just about everything. Nolan, go ahead.
I have some quick questions.
Please.
The 6 people that concurred with Tony,
I think it was 7-2, yeah, it was, I guess, 5 plus 1, yeah, go ahead.
did they do it for the same reason Tony did, to try to resolve this slavery issue once and for all, or did they actually agree with this interpretation of the Constitution?
Well, at the time, the majority of the court were Southerners. Okay, why was the majority of the court Southerners? Because most of the presidents were Southerners. Why were most of the presidents Southerners? Because of the 3/5 compromise, right? If you recall, under the original Constitution, slaves were counted for purposes of representation at a rate of 3/5. As a result, the Southern states had a bonus in the Electoral College. They had more votes in the Electoral College because of their slave population, who couldn't vote, who had no rights at all. So most of the early presidents were Southerners who support slavery. And as a result, most of the presidents who support slavery appointed justices who support slavery. So I think, Nolan, my answer to your question is a little bit of both, right? They were probably sympathetic to the majority, but they also probably want to resolve this issue as well. Let's go into the dissents for a minute. You have 2 dissents. I think the first dissent was Justice Curtis. I'm sorry, I flipped in order, yeah. But Justice Curtis was from, was he from Maine? I think he's from somewhere in the Northeast. He was born in Massachusetts. And Justice Curtis, no, Justice McLean, where was he from? I can't remember where he was from. He was from Ohio. So I mean, you basically had two Northerners who both cast votes in dissent. Matt, you want to walk through the dissents, please, or at least just sort of a high level? Okay. There were two dissents. Vote was 7-2.
I want to say that Curtis dissented, he basically disagreed with the entire concept of blacks having no citizenship and no personhood, and was fairly rejected the entire concept that
Yeah.
based his
Very good.
his case on. I need to refresh my memory a little bit on this one. I feel like he has much more narrow, description.
I can help out on that one.
Oh, you did? Okay, go for it.
Framers, he had a view that the framers, particularly like Madison, were careful in wording of the Constitution in regards to not mentioning slavery and particularly like who can become a citizen, specifically for the fact that it would affect the southern states joining the union.
Okay, very good. Thank you. You want to add something?
Yes, I think that Justice McLean also argued that there were like 5 states at the time that
Yeah.
were allotting voting rights to free African Americans.
Very good. Framing, there were a handful of states, 5 or 6 of them, almost half, in which free blacks were allowed to vote. Right? And that undercuts Taney's argument to the contrary. They also argue that if Taney's right, then states may not even be able to abolish slavery. Right? If Taney's right that slave owners have this constitutional right, that these people are not citizens by any regard, then even free states cannot abolish slavery. Here was the fear. If Taney was correct that slavery could not be abolished in the territories, there might be another decision down the road which holds that Massachusetts can't abolish slavery in its own people, which would have been a huge decision because Massachusetts had gotten rid of slavery almost 100 years earlier. Right? And that was the fear of Roger Taney. That was their fear altogether. Okay? There's also sort of an argument which doesn't get much weight today, but the federal government has the power to abolish slavery, right? There's a provision in the Constitution which no one ever cares about called the Property Clause, right? Article 4, Section 3. And it says, the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory of their property belonging to the United States. What does that mean? Well, the dissent says that means they want to abolish slavery in the territories they can do it. How did Taney read the Property Clause? This is one of his more insane holdings. Ready for this, guys? Ready for this? Taney says, well, Congress has the power to regulate the territories that were in existence in 1787. I said it again. Taney argues that Congress can only regulate the territories that were in existence in 1787. In other words, the Wisconsin territory was new, therefore Congress had no power over it. This is insane, right? If that's actually the argument, then Congress has no power to do anything for any lands acquired westward, right? So you're saying, I'm trying to tell you, he had to like bend over backwards and reach so many bizarre conclusions to get to the result that he got to. Yeah.
I have to ask a question.
Of course.
Did he genuinely wholeheartedly believe in all this, or was he just doing this as a matter of
I don't know.
in the Constitution?
You know, look, it's a good question. I don't know what was in his mind. I couldn't tell you. Again, he was a smart lawyer. You read some of his other decisions, and they're completely well reasoned, right? It's not like he was, insane. But for whatever reason, he decided that this was an opinion he had to write, and he wrote what he did. And history can judge him for that, for what he did. But there also are 6 other people who joined him entirely. So it wasn't just him, right? He wrote it, and he gets all the shame, but he had people join him. Yeah.
They didn't know at this point that the Civil War was coming.
It's a good question. I mean, directly, no. The timing of this was that Dred Scott was at 1857. Let me go by a year or two. It was 57. Yeah, 57, 1857. Thank you. So I mean, they were, a couple years away, but I don't think they knew that there was going to be a war, right? They knew there would be some sort of increasing tensions between the North and the South, but they didn't probably appreciate it would be a bloody civil war that lasted for 4 years. In many regards, Dred Scott, the decision, didn't cause a civil war, but I think it certainly accelerated it. And let me now transition to the post. Any questions on the dissent? I think I got the dissents out. Any questions on the dissents? All right, let me transition to the post-Dred Scott discussion now. After the decision, it was very unpopular. Abraham Lincoln was a lawyer from Illinois who rose to national prominence by denouncing Dred Scott, saying how it was wrong, that you can't have this. Lincoln famously argued that a house divided cannot stand. That is, you can't have a nation half free, half slave. It wasn't going to work. Now, how that would resolve, he didn't know himself. It wasn't clear. But it was either going to have to be all or nothing. You couldn't do this half anymore. Lincoln ran for president in the election of 1860. And the Electoral College was divided 4 different ways. Lincoln won the ballot. He had a majority of the electoral votes, but he did not receive a single electoral vote from the South, not one. In fact, he wasn't even on the ballot in most southern states. They just didn't put him on the ballot to vote for. What happened next? Lincoln took the oath of office in 1861. Shortly before he took the oath of office, a number of southern states seceded. Who administered the oath of office? Roger Taney. Can you imagine that scene? Just. I mean, there are pictures. You can't really see what's going on, but there are pictures of it, right? Where Roger Taney wrote this decision, saying that there was a constitutional right to slavery, and then Abraham Lincoln was elected, arguing that Taney was wrong. So you basically have Taney giving the oath of office to Lincoln. Just try to picture that scene for a minute. It's a remarkable scene. You can imagine, that must have been one hell of a handshake, right? But Lincoln gives the oath to, Taney gives the oath to Lincoln. Shortly thereafter, the first shots are fired. Fort Sumter was a military base in South Carolina. And the Confederate forces fire on this federal institution, right? You basically have U.S. citizens opening fire on a federal military base. And usually, imagine some random jerk runs up to a military base, starts shooting at it. What's going to happen, right? The government's going to arrest him and throw him in jail, right? But here, the federal fort was under such heavy fire, they had to surrender. And they surrendered to the base. And there was actually a lot of ammunition, and there was gold. There was stuff in this base that they took. It was deliberate. They attacked it. At that point, Lincoln called up the militia in these states to try to put down this insurrection. Well, guess what? Who were the militia? They were the people of South Carolina, and they didn't want to fight against their fellow Confederates. So the remaining southern states then seceded. Now, we talked about this when we did Ex parte Merriment. Lincoln never acknowledged secession, right? He never said, you know what, there's this new country. It's called the Confederate States of America. Their capital is in Richmond, Virginia. I'm going to send an ambassador there to help negotiate peace, right? That never happened, right? Lincoln maintained until the bitter end that this was no civil war. This was no nation against nation. This was not a separate government. Rather, these were traitors. These are people who betrayed their oath, people who were taking arms up against their own country. Think of like a mutiny on a ship, right? These were traitors. And they can be prosecuted as traitors. It's not a foreign belligerent nation. And this was an important position because there was no declaration of war. To have declared war would be to concede there's another nation to declare war against. Lincoln would not acknowledge that. These were still Americans who were traitors. Everyone with me? Okay. The war went on for many years. It was bloody. It was violent. Brother against brother fighting. But eventually, the Civil War drew to a close. Lots of great books and movies in the Civil War. You can go watch stuff, but that's all we're getting for today. After the Civil War concluded, the southern states were basically not allowed back into Congress, right? The Republicans in Congress said, no. You guys are a bunch of traitors. We're not letting you back in here to vote. So the first few years after the Civil War, it was almost entirely northern states in government. They were making all the laws. This was a group called the Radical Republicans. At the time, the Democratic Party was associated with the Confederacy, and the Republican Party was associated with the abolitionists. Okay? And the Republicans in Congress recognized something. They recognized that whatever they did by legislation might not be permanent, right? They needed something more solid that could last. So they decided to amend the Constitution. And in the span of less than a decade, Congress enacted 3 amendments to the Constitution. We call these amendments the Reconstruction Amendment. I'm sorry, Reconstruction Amendments, plural, there are 3. It's the 13th Amendment, the 14th Amendment, and the 15th Amendments. And to understand the 13th, 14th, 15th Amendments, we have to understand Dred Scott. What these amendments were designed to do was reverse Dred Scott. The Supreme Court never ruled Dred Scott, just it never had to. What overruled Dred Scott was not the Supreme Court, but the people through amendments to the Constitution. Okay, let's start with the 13th Amendment. It provides Section 1. Neither slavery. Yeah.
Quick question. So, is it like ever possible like that an amendment could be like it is not constitutional?
Say that one more time. I think I understood your question, but say it one more time.
Yeah. And so just like that you said, the Congress at the time was all like the northern states.
Right.
So is there like argument to say that it's unconstitutional? Because not all the states were.
Yes. So let me put it this way. There are a lot of fringe theories, right? People who are insane, right? And a common fringe theory is that the 14th Amendment is unconstitutional. Huh? It's not insane, but it's pretty fringe. And the argument's like this. The southern states were not truly in Congress. And because the states were not able to vote or not vote, their vote shouldn't count. Let me one-up Tanner's question. There were some states that were given a choice that if you want to come back into the Union, you have to approve the amendments. In other words, coercion, right? Think of like the coercion doctrine in contracts, or maybe like the Obamacare case, right? Give us your consent or we're not going to let you back in the Republic. So there are considerable people today, I shouldn't say considerable, but there are people today who believe that the amendments are unconstitutional. Now, this usually comes up with the income tax amendment. If you want to see some insane people, remember Wesley Snipes? You know the story? How he says the income tax laws doesn't apply to us? One of the arguments these people raise is that the income tax amendment is not valid because the states were not properly admitted into the Union after Reconstruction. This is bad. Sorry, this is crazy stuff, right? I don't want to make light of Tanner's question, right? Because I think it's a good question. But there are people who believe that the amendments are not valid, and therefore they don't have to pay income tax. You know, of course, that's what it means. You don't have to pay damn income tax. Yes, Rosh.
To answer also, wouldn't then technically going, if a state was admitted after January 16, 1919, 1933, and they were all about booze. Couldn't they technically argue the same thing, that, hey, we didn't get a vote on the...
Well, that's a different question, right? Are later admitted states bound by earlier amendments? And I think that's an easier question. When you join the union, you join it knowing what the laws are. You have the choice whether to join, so you accept the amendments as they are. So I don't think that's quite right, but I see what you're getting at. But I do want to take Tanner's point well, right? Could an amendment to the Constitution be unconstitutional? Right, it's an insane question, but this is actually, I had an exam question on this a few years ago. Remember, there's a provision in the Constitution that says that the fugitive slave trade cannot be eliminated before 1808. Remember it says this? What if Congress in 1807 passed an amendment saying we're getting rid of it now? The original Constitution said you can't do that, and they passed an amendment saying you can.
Isn't there a provision in, I think it's Article
Yep.
Article 4 that says that certain articles can't be
Yep.
adjusted?
Yes, if you go to Article 5, I think it's in Article 5.
Article
It's, I think it's, yeah, it says,
Yeah.
at the very last clause of Article 5, it says, no state without its consent shall be deprived of its equal suffrage in the Senate. What does that mean? Each state gets 2 senators. Could Congress pass an amendment saying California gets 3 senators and New Hampshire gets 1? That seems to say no. Can you have an unconstitutional amendment? It's actually like a very deep philosophical question. But I have a friend. His name is Richard Albert. Teaches at UT Austin. He writes about this. Can you have an unconstitutional amendment? Right? Does the ratification process? Or I'll give you one more. The Articles of Confederation provided to amend it, you needed unanimous consent. Right? All the states had to agree to change the articles. Our Constitution was ratified with 3/4 consent. Is our Constitution unconstitutional? Whoa.
Technically until 1790 when...
The 13th state came along, yeah. Was that mean our first 3 years of government should be valid? All the laws they passed were void?
According to the Articles of Confederation.
So now we're getting to the weeds. Hello, welcome. Right, now we're getting to the weeds, right? So is our Constitution unconstitutional? I don't know, maybe. I try not to think about those things. It'll keep me up at night way too long. I have enough problems dealing with what we have, so we're going to table your question, but pay your income taxes. That's what Wesley. Do not take tax advice from Wesley Snipes. You will go to jail. He went to jail, didn't he?
Yeah.
I think. Yeah, Matt.
Isn't an amendment a change to the text of the Constitution?
Well,
So that couldn't be unconstitutional by definition.
but what if the Constitution says you can only make a change with X and we decide to make a change through process Y? That's an amendment.
Right. But you're changing the law that says that you have to do process X.
Well, let me give you one other thing. Let me give you one other. I don't want to get too far into the weeds. Why do we put the amendments at the end? Why don't we just cross the fat in the middle? So, for example, the 14th Amendment killed the 3/5 clause. Why do we put that at the end? So saying, it no longer applies, right? Your little Constitution has these little asterisks, right? These little footnotes. I don't like those. I don't like putting them there because I think they're not real. But why don't we do that?
That's a good question. That's what they're doing.
just wanted to-
Exactly. In a statute, I'm sorry, Nick, but in a statute, you put it right there, this has been repealed right there in the text. We don't do that.
I
Yeah.
just wanted to clarify the point. The Constitution says that no amendment can be made prior to
1808. Yep.
1808 in any manner affecting the first and fourth clause of the 9th section. The first clause of the 9th section is
The fugitive slave clause.
regarding fugitive slave clause. So the
I'm sorry, fugitive trade clause. I'm sorry.
Yeah, so the Constitution prohibits an amendment.
But what he's saying is that by making the amendment, you're undoing that part of the Constitution.
Not if the original text of the Constitution says you can't
Okay.
make that amendment.
Oh, we're going way
Yeah.
into the weeds. I'm gonna cut this off here because I think it's too much fun because I have other stuff I want to cover. But I think you're all thinking in a very good wavelength, and I like where you're thinking. But this hole just leads to Wesley Snipes, so just stop digging. Right? You're gonna go into Wesley Snipes land, and then you're in trouble. But if you're ever really bored, Google fringes on a flag. You know these people? There's a thing that if a flag has fringes, it's actually a court of admiralty, so that there's no jurisdiction. Just Google. Let me take one step back. There's a group called the Sovereign Citizens. Have you heard of these people? People are nodding. They're around. And they argue that they are sovereign citizens, that is, they're not subject to our laws, and they have their own jurisdiction. Like when I was clerking, I had one case where this guy got a parking ticket in Philadelphia, and he refused to pay because he said, I am a foreign government, and you cannot give a parking ticket to basically an ambassador, he called himself, right? An ambassador to which country? Me, right? These people exist, and their thing is like the fringes in the flag, so it's not a real trial because it's a court of admiralty. I don't know. Just Google this stuff. These people are nuts. I shouldn't say that. They base their ideas on these very bizarre theories of the Constitution, kind of what you guys are asking about now. So they're not. That's why I want to be charitable, not call them insane. But they don't pay their parking tickets in Philadelphia. Okay. All right. Let me go on. All right. So the 13th Amendment, and I want to just focus on the text for a couple minutes here. It says, neither slavery nor involuntary servitude, except as a punishment for a crime where the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. All right, so there's a lot going on here. So I want to focus on the first 5 words. Neither slavery nor involuntary servitude. Oh my God, I'm going to call him. He's not here. Oh God, Josh, you're breaking my heart. Sorry. Hannah, you're next. I'm sorry. I know you're going to be very mad at him later. Hannah, it says neither slavery nor involuntary servitude. What's the difference between slavery and involuntary servitude? Are they the same thing or are they different? Oh, now he comes back. Josh, you have the next question, by the way. You have the next one. Yeah. Hannah, what's the difference between slavery and involuntary servitude? Are they the same thing? Are they different?
I don't know what the difference would be.
Well, the fact that they're listed next to each other, does that suggest that they're the same or suggest that they have different meaning?
Different.
Okay, so that's the first thing I want you guys to understand. It doesn't just say slavery is not allowed. It uses these 2 phrases, slavery or involuntary servitude, which I think, and no, this is Josh talking, but I think at least that means there's something different, right? So Josh, I'll ask you this question now. What might the difference be between involuntary servitude and slavery? What might the difference be between the 2 concepts?
I guess probably like involuntary servitude would be more so. I'm looking at like I guess like a prison sentence or something like that. In a way.
Well, which one's broader, slavery or involuntary servitude? Slavery, I think, is broader, right? So let me. This is sort of the way I look at it, and there's not a right or wrong answer here, I don't think. But involuntary servitude is not in the prison context, because you look at the next clause, right? Because you can have servitude when it's punishment for a crime. So think of a chain gang, right? You ever see the "Oh Brother, Where Art Thou" movie, right? Where these guys have these chains and they're picking up garbage inside the road. Quite literally, being in prison is involuntary servitude. You're there against your will. That's what prison is. Right? So I don't think it's the prison stuff. But servitude means you're basically working against your will. Right? You're involuntary. You're a servant. You're working. But slavery was something bigger. I'll get you a second. Slavery was something bigger. And at the time, the word slavery wasn't just the actual chattel slavery, right? The person was bound to labor. It referred to like an economic structure, a legal structure, if you will, which involved the black codes, what you would call today Jim Crow, where people were basically subordinate, where even if you were a free black, you couldn't travel, you couldn't own property, you couldn't give testimony in court, you couldn't work, you couldn't do all the things that citizens ought to do. The 13th Amendment wasn't just about eradicating chattel slavery. It did something more than that. It abolished the institution of slavery. And I want you to keep that phrase in mind, the institution of slavery. We'll come back to this in a few cases, this topic. But it did more than just get rid of the actual ownership. It went beyond this. How far beyond this is a question the courts grapple with. But it wasn't just about slavery and servitude. Yes, Rosh.
Well, I was just going to define.
Please, give us your definition.
So slavery is basically complete lack of freedom or liberty, whereas involuntary servitude is compelling you
To work.
To work.
Yeah. So it's a loss of certain types of liberty is what you're getting at. Yeah, David.
You said that like working in a prison wouldn't be involuntary servitude.
It would not be because it specifically says if you're
Right.
been convicted, it's like a carve out.
But even though it's an accept, because I mean to me that reads as.
Well, in other words, it's permissible. It's permissible in voluntary servitude if you want to read it that way.
That's kind of.
Yeah, I want the same thing, right? But it's not prohibited by the Constitution, right? You can imagine if the 13th Amendment was written and this clause wasn't added, everyone in jail's like, ha, I'm being held against my will. So that didn't go too far. Now, but I do want to point this out. A lot of southern states took advantage of that clause. How? They made up bogus crimes, right? Working without a permit was a crime, right? Working without authorization from the state. So in other words, someone got a job without permission from the state, they were breaking the law. Some states made it a crime to be unemployed, vagrancy, basically. So basically, if you were working, you were committing a crime. If you were unemployed, you're committing a crime. It was just a way of locking people back up in quasi-slavery, right? And the punishment was to work for someone. So I don't want you to forget about the second clause. This was taken advantage of in a very significant way in the years that would come. But I want to focus on the text just for a minute, okay? Okay. Neither slavery nor voluntary servitude shall exist. This is an important point. Up until the 13th Amendment, government only limited state actors, right? You can't take property, right? You can't establish religion. You can't regulate interstate commerce, right? Everything in government was about limiting government power. But the 13th Amendment was unique. It did not only apply to the states. It applied to private individuals. Let me say it again. When he says it cannot exist, it means anyone. Private individuals were now prohibited from having slaves. Why is that significant? Because this applies nationwide, in free state and in slave state, in free territory and in slave territories, right? If you were a human being, you can no longer be held as a slave. This was a fundamental transformation of government, where the government said to individuals, you cannot do this. Congress before had never had any business in what private people did. They might tax them, whatever, but they couldn't tell them what to do. This was a huge change. Slavery shall not exist. Everyone with me? Right? There was yes, Josh.
So I don't know if I'm reading it like, or if my grammar is off or whatever. So it's definitely right. Involuntary servitude is no more, with the exception of
That-
punishment for crime.
Yeah, that's
Can it be read
David's
as
question.
slavery?
What?
Can it be read the same? The way it looked to me is like slavery could also be used as a punishment for crime.
Oh, I see what you're saying. You're overthinking it.
Okay.
Yeah, no, I mean you're not wrong, which is why I didn't like David's proviso. I would just say that you can basically lock someone up for a crime. I wouldn't say that. I don't think I would call jail slavery, but I guess you could use that phrase. But just don't overthink it too much. The text of this would matter though with the involuntary servitude part, right? Because if you want to take slavery seriously, that means it goes beyond the punishment for the crime. It's a lifelong thing. Whereas with an involuntary servitude, it might be for a 5-year term or something. Okay, everyone with me?
Will it be more like indentured servitude then?
Yes. In other words, you could still be an indentured servant because you're basically consenting to it, right? It's voluntary, right? The point of being an indentured servant is you choose to have it. This is involuntary. It's not your choice. It's forced upon you. Okay? Everyone with me, guys? Okay. All right, so the 13th Amendment was ratified, God, what year? 1865. Did anyone see the movie Lincoln? I didn't like it. Did you like it? You think I'd love a movie about the Constitution? I didn't like it. I was bored, but whatever. I didn't like it. But the entire premise of the movie is that one of Lincoln's last acts before his assassination was to push for the ratification of the 13th Amendment. And this is one of his last major acts. And the movie basically ends with the ratification of the 13th Amendment coming up. Okay. All right, so now Congress enacts the 13th Amendment. Did that abolish slavery? Absolutely not, right? There was massive resistance, widespread resistance. The southern states were just not going along with this, right? They were like, no, thank you, right? We're not doing this. As a result, Congress began a process known as Reconstruction. Reconstruction. What is Reconstruction? Quite literally, to reconstruct the South, to build it up from the bare bones. The Southern governments were basically dissolved. It's remarkable. Congress sent, right? Congress basically established fake government. I shouldn't say fake, but Congress basically established governments in the South for them. I'll give you an example. Who was the first African-American U.S. Senator? His name was Hiram Revels, R-E-V-E-L-S. He was elected in Mississippi in the year 1870. Can you imagine? Less than a decade after the Civil War began, you had an African-American elected to the Senate. Why? It was based under federal supervision, right? You actually had people monitoring elections, ensuring fair elections, all this other stuff. You actually had this. Now, he served basically one term. I think he was there for 2 years or so. It didn't last long. But this process at least started off, I think, on a positive footing. And one of the laws Congress enacted in 1865, was called the Freedmen's Bureau Act. Was it 65 or 66? Might be off on the year. 66? I'm sorry. Thank you. Yeah, I know I was off by a year. I shouldn't doubt myself. Okay. Okay. So there were two laws passed in 1866. There was the Civil Rights Act and the Freedmen's Bureau Act. Okay, there was the Civil Rights Act and the Freedmen's Bureau Act. All right. What were these laws? These were laws designed to assist with Reconstruction. Okay? The Civil Rights Act of 1866 said that all persons who were born in the United States were citizens. Okay? That all persons born in the United States were citizens. But wait a minute, Josh. Didn't Roger Taney and Dred Scott tell us that's not true? Didn't Roger Taney tell us that black people could never be citizens? He said that. And what did Congress do? They said, never mind. Now, were they ignoring Dred Scott? No. They argued that now the Constitution was changed. They argued that because the 13th Amendment was ratified, Congress now had the power to grant citizenship to the freedmen. Right? That Congress had the power to grant citizenship to the freedmen. And the Civil Rights Act also gave the sorry, when I say freedmen, it's not just men, but it was women also. But that was the phrase, freedmen, right? When Congress passed the Civil Rights Act, it gave the freedmen other rights. The rights to make and enforce contracts, to sue, to give evidence, to purchase property, to have the full and equal benefit of law. Right? This was a law, the Civil Rights Act, that was designed to bring the freedmen back into the country. It was to give them citizenship, to give them rights to own property, to give them the right to inherit. Think about that. If you couldn't inherit property back then, there was no wealth. Wealth is all based on inheritance, right? You can now inherit property. All right? Then Congress enacts the Freedmen's Bureau Act in 1866, the same year. Okay, what was a Freedmen's Bureau Act? It created basically an administrative agency to advance the interests of the newly freed slaves. It also gave freedmen the right to bear arms, which is actually very important. At the time, you had these lynch mobs. Basically, the Ku Klux Klan, we would call it today, what became known as, would terrorize people in the South, and they would try to disarm them. And the Freedmen Bureau Act ensured that people had the right to bear arms. But the debate arose. Did Congress have the power to enact the Freedmen's Bureau Act and Civil Rights Act based on the 13th Amendment? In other words, did the power to abolish slavery give Congress this authority? There was a debate. Even among the radical Republicans in Congress, there was disagreement. Some of the members of Congress said, well, of course we have this power, right? Slavery is this institution we have to abolish. And in order to abolish this institution, we need to get rid of Jim Crow. We need to get rid of the Black Code. People have property, right? We can't have this stuff. Other people were nervous. Other people said, well, this is dicey. What if we say that Congress has this power and the Supreme Court comes back and says, no, you don't? Right? This was a difficult time. What if the Southerners come back into power and they put more Southerners on the Supreme Court and they argue that you don't have this authority? What if the Southerners come back into power and they repeal these statutes? They repeal these statutes. At that point, all the hard-fought victories for race would be dissolved. So they recognized they couldn't hang something of this importance on a mere statute. They recognized that they had to adopt not just a statute, but a constitutional amendment. And that gave rise to what we now call the 14th Amendment to the Constitution, which is, I think, probably the most important amendment we have. You might say First Amendment or whatever else. This one transformed our government in remarkable ways. And I want to walk through the sections one at a time. There are 5 sections. I'll just do 1 and 5 today, but there are 5 sections. I'll walk through one clause at a time. So it begins. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This first sentence overruled Dred Scott. Done. Right? Dred Scott said, you're not a citizen. Section 1 says, yes, you are. Yes, you are. You are a citizen by virtue of your birth, not based on your parents' citizenship, not based on who your grandfather was, not based on, what the laws of a state are. You're a citizen. And look what it says. You're a citizen of the United States. What does that mean? You get to go to federal court. You get to go to diversity jurisdiction. What does it also mean? You get the privileges and immunities of Article 4. So if you are a sailor going from Massachusetts down to South Carolina, now South Carolina must afford you the same rights it gives its own citizens. But you're not just a citizen of the United States. You're also a citizen of the state where you reside in. In other words, your state cannot treat you as a second-class person if you are a citizen. This reverses Dred Scott. This answers a debate between Frederick Douglass and Garrison, right? This resolves a debate and says there's no longer a discussion. We have now a constitution that eradicates slavery. And what's the consequence of this provision? The 3/5 clause, which says other persons are only afforded 3/5 of the vote, representation, gone, right? The 14th Amendment wipes out the 3/5 clause. What about the provision saying people held to service or labor? Gone. You are now a citizen, right? Now, it doesn't actually cross out those provisions. They're still there, but it has no effect. A couple of years ago, the Congress decided to read the entire Constitution from start to finish, which I think is a wonderful idea. But when they got to the 3/5 clause, no one wanted to read that out loud, unsurprisingly, right? When they got to the Fugitive Slave Clause, no one wanted to read that one out loud, unsurprisingly. They're still part of the Constitution. We don't do as Matt said, we don't cross stuff out. It's still there. I mean, I know your little pop Constitution, but it's a little star. I'm not a fan of. I don't like that, but I go along with it because it's, it helps students understand. But I think we have to recognize, it's there. Think of if you get into a really bad injury, you have a scar, right? You healed from the injury, but the scar is still there. It's a reminder of where you were. And that's how I kind of see it. I think the 3/5 clause is like a scar, right? Scar tissue, whatever you want to call it, that reflects a past wound from our Constitution. In many regards, the 14th Amendment tried to heal that wound. Did it? We can argue for months, but I think those provisions should, you should know they're in there. They're not. We don't just take white out, right? We don't just white them out. They're there. We don't just cross. They're there. Okay. Questions so far? Okay, that's the first sentence. The next sentence is very significant. It says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." This puts a restriction on the states. The states cannot violate these rights, these privileges or immunities. In other words, it doesn't matter what rights a state gives its own people. Now the states can't violate these other rights. These rights, I will do a case tomorrow, or I'm sorry, on Thursday, called the slaughterhouse cases. And preview, the court read this provision very narrowly, so a bunch of rights that aren't very important. But this was significant. Okay, any questions so far? Next one. "Nor shall any state deprive a person of life, liberty, or property without due process of law." Right, again, this wipes out Dred Scott. A person has liberty. A person cannot be held in bondage. And now states are no longer permitted to deprive people of their rights. And then the final one, it's the Equal Protection Clause, which you probably have heard of. It says that a state cannot deny to any person within its jurisdiction the equal protection of the laws. What does that mean, equal protection? Does it mean the state must treat people equally? Or does it mean the state must provide protection to people? Today, the courts say this means that states have to treat people equally, treat white people and black people alike. But the word here is not treatment, it's protection. And you have to think of how things exist at the time. You had state lynch mobs, former Confederate soldiers who would basically kill free blacks. They would just murder them in some gruesome fashions. The state didn't protect their people. I mean, you don't think about this. When you call 911 and say, "Please come to my house to protect me, there's someone trying to break in," does the state have an obligation to actually do that? Or they, "No, you know what, Josh, you're kind of a jerk. We're not going to come over. We don't like you very much." Or, "You didn't pay your taxes. We're not going to help you." Or, "You know what, you voted for the other guy. Screw you. I'm the sheriff, not helping you. You vote for my competitor," right? The idea of protection is the state has to actually provide some protection for you from violence. The reason why we have governments protect us. If we were all just by ourselves, we could just defend ourselves. But we have a society to provide some form of protection. So this provision was probably best understood originally to mean the state's got to protect their people. They can't let them get murdered from the lynch mobs. But that's not how the courts read equal protection today. The last provision, and I'll wrap up after that one, is Section 5. We've talked at Section 5 before in our discussion of the 11th Amendment. Right? Remember we asked, does Section 5 give Congress the power to waive or abrogate a state's sovereign immunity? And in Bernie v. Flores and cases like that, the court said sometimes, right? This is the congruence proportional test. But at a minimum, Section 5 is important. Because if a state is not guaranteeing due process, Congress can enact legislation. If a state is not protecting their people, Congress can enact a statute. So for example, if the state fails to protect the rights of its people, Congress can say, okay, you go to court, you can sue the state for damages, right? That's where this came from. This is not about like Religious Freedom Restoration Act. This came much later. It's if a state is not giving its basic people to its rights, other way. If a state is not giving its people basic rights, they can go to federal court and sue. Okay, everyone get the frame. Now this all looks great. Oh, Josh, Section 1, Section 5, this is great. This is going to end all these racial issues, right? Not quite. Not quite, my friends. In a series of decisions, the Supreme Court would basically delete this entire thing from the Constitution, right? The first sentence wasn't really challenged. People said, fine, you're a citizen. The second one was the Due Process Clause. The Privileges or Immunities Clause, right? The court basically said, what are these privileges and immunities? Federal rights, like the right to access government and the right to protection of the high seas. In other words, nothing very important, right? What about equal protection? Does that mean you have the right to be protected from a lynch mob? Nope, no you don't, right? That's not what it means. What about Congress's powers to enforce this? Well, it doesn't really get you very far. Congress can't do too much. In a series of decisions, the court read this provision very narrowly. And we wouldn't actually get a meaningful civil rights law upheld until 1964. Yes, roughly 100 years after the Civil War. The Supreme Court finally upheld this sort of provision. We studied Heart of Atlanta, Hotel, remember this one? And Katz and Vacuum McClung, remember the barbecue case from Birmingham, right, Ollie's Barbecue? You have this huge gap. And the Supreme Court's decision to sort of remove these clauses from the Constitution, I won't say enabled, but allowed Jim Crow to rise without any sort of judicial resistance. And after the Grant administration concluded, Congress pulled out of the South, and Reconstruction terminated. That's why my friend, Mr. Hiram Revels, only served a term in Congress, because once Reconstruction was concluded, the southern states began implementing what were called the Black Codes, the Jim Crow laws, which did not resurrect slavery in its formal capacity, but it resembled it in many regards, right? And they basically resurrected the condition of slavery, so things resembled in many respects how it was before the Civil War. So the next couple weeks of class are kind of, I don't want to say depressing, but they got some lows. It gets a little better later, but you're going to see some decisions from the court that aren't so good. You have the slaughterhouse cases. You have a case called the civil rights cases. You have a Plessy against Ferguson. You get it's going to be some pretty rough cases. So the first half of the semester is kind of boring. Like, who really cares if South Dakota loses highway funds? Like, does anyone actually care? No. Right, does anyone actually care if the Gun-Free School Zone Act is unconstitutional? No, you actually don't care. But these cases are different, and I think they're read on a different level. So I just want you to keep that in mind as you go through the readings for the next couple of classes. The first half, I like it, but it's kind of boring. It's kind of dry. Does anyone really, really care about the Bank of the United States if it was constitutional? No one actually cares, right? About a steamship going from New York to New Jersey? No one actually cares, right? I care, but no one really cares. This stuff, I think, is different because it has a salience that is both contemporary but historical. Okie dokie. Questions for me now? Okay, our next class, we meet again on Thursday. We talk about the Privileges or Immunities Clause. We'll do Slaughterhouse, Bradwell, and Cruikshank. Cruikshank is a tough case to read. I encourage you to watch the video if you haven't, the video on the 13th Amendment, 14th Amendment. Just watch it. It will give you a lot of good background. And if any of you are fasting tonight, have a good fast, have a good Yom Kippur. I will see you on Thursday. Thank you.